بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم على سيدنا ومولانا محمد وعلى آله وصحبه وسلم. اللهم فقهنا في الدين وعلمنا تأويل وألهمنا رشدنا يا رب العالمين. اللهم أرنا الحق حقا وارزقنا اتباعه وأرنا الباطل باطلا وارزقنا اجتنابه ولا حول ولا قوة إلا بالله العلي العظيم. اللهم إنا نستهديك لإرشاد أمرنا وزدنا علما ينفعنا وعملا يرفعنا وأحوالا وأخلاقا ترضى بها عنا يا أرحم الراحمين. اللهم افتح لي بحكمتك وانشر علينا رحمتك يا ذا الجلال والإكرام. صلى الله وسلم على سيدنا محمد وعلى آله وصحبه وسلم. Alhamdulillah. So a warm welcome to episode number 9 in our series of Rasa'i'l Readings. And Alhamdulillah, it's nice to be back with everybody. And Alhamdulillah, with this time with the risala في مسألة زوجت وجوزت. So it's quite so this is quite an interesting risala. It's quite an interesting issue. And also the author is very significant. But I guess I'll address things in the order that I just mentioned them. First of all, it's a very interesting issue because I personally have experience with this issue. That I was once abroad, and I was actually asked this by a taxi driver whom I had hired to take me frequently on a frequent basis. Had like a class, so it was the same guy. Then one day he just happened to ask me, is جوزت. So he kept asking me, جوزت. And I was really confused. I didn't really have any idea what on earth he was talking about. Until eventually, it became very like he became quite forthcoming. It was quite obvious what he was asking, and then I clarified at that point. But that was my first experience, and I found that extremely strange that somebody would just mix around the letters, and so what's quite fascinating is that this is not it wasn't something specific to the population even to the population even now. Rather in it seems that in this area and perhaps even beyond that, certainly in these Arab speaking countries, there is some tasahun, laxness as it were, with respect to pronunciation. Right? So they're not necessarily saying things as they are supposed to be said. And of course, there's many other words and like which manifest through the the Ammiya, which is like not the formal Arabic, but it's through the dialects with which people normatively speak. So anyway, so that's the reason for why it's quite an interesting issue. Of course, it was subject to a bit of debate as well. Inshallah, I'll clarify what that is a bit later on. But the second thing that I want to mention just about this risala is I think this is probably the most technical risala which we have would have read. If we, in light of if it's between this and the previous ones, there are lots of technical kind of issues that he ends up talking about over here because he's trying to explain out this issue quite thoroughly. Thankfully, however, he is relatively brief, so I don't imagine that we will go on for as long as we might have done in previous episodes. So inshallah, everybody will be able to keep up with it. Of course, as I've mentioned before, the purpose of these sessions is not necessarily to do ta'sis. It's not necessarily that you come and then you learn, quote unquote, the madhab from these types of sessions, but it's to supplement your other studies and the like, even if, of course, you do end up learning something. I'm not suggesting that you won't learn anything, but it's important for everything to be contextualized as well. And you don't necessarily get all of that, particularly when the ulama are trying to speak to a certain reality or speak in a certain context, and also there might be lively debate about a certain issue. We don't necessarily get all of that if we are reading just one short risala on the issue, even though I'll be bringing up something else a bit later on. But it does get a mention. The author himself, he does mention it in some of his other books, and then later authors also engage because of the fact that Shamsuddin here, Muhammad ibn Abdullah al-Khatib al-Tumurtashi, is al-Ghazi. So of course he is from Gaza. فرج الله تعالى عن إخواننا في غزة. Ameen. Allah subhanahu wa ta'ala grant a relief to our brothers and sisters in Gaza and the Holy Land, and grant them every solace from all of their difficulties and hardships, and grant them a victory, and grant them success in their endeavors. I mean, so he's actually from Gaza. He's a Gaza native, so he's one of the homegrown scholars of Gaza in the 10th, 11th century here. There's some debate about when he passed away, but he is probably one of the most prestigious scholars from the region in the later times. So in the latter period, I mean in the period of what I'll call the later Hanafis. So he studies actually with the likes of Ibn Nujaym and Aminuddin ibn Abdul Al, who are major Egyptian Hanafi figures. So he goes from Gaza to Cairo for more studies, and he writes, of course, ends up writing the seminal text, which is the Tanwir al-Absar wa Jami' al-Bihar, I believe the full title is. And this is a tremendous work, really, which becomes subject to, first of all, his own commentary. So he writes his own commentary on it. But then it also has many other commentaries by other scholars, most notably Alauddin al-Haskafi, who is the Mufti of Damascus. That itself is also the subject of many commentaries. And perhaps the most important commentary is that of Muhammad Amin ibn Abidin. So Ibn Abidin's Hashia is a Hashia on Haskafi's commentary of Tumurtashi's Tanwir al-Absar. So he is quite an important figure. He has many other works, and he has many Rasa'i'l on all kinds of issues. So he is quite an important figure in the later madhab. So alhamdulillah, we have been exploring different regions, I guess, in terms of some of the authors and some of the Rasa'i'l which we've been looking at. We've looked at Ottomans, and we've looked at I guess we looked at Mullah Ali al-Qari, who, I guess it depends on how you want to conceive of him, but he's known as al-Makki, but he's from Herat and Afghanistan and the like. So anyway, I think we've kind of looked around at different places, and inshallah we'll continue to do so, because there are just so many issues which have been discussed by the ulama, and it's part of what we're trying to do here is for people to appreciate the discussions which are happening, and the lively nature of those discussions sometimes, and how the issues of the madhab are being discussed across the Hanafi lands. So alhamdulillah, inshallah, without any further ado, we will jump in to this risala. Of course, it's not the best version, but I guess there aren't any other versions that I'm aware of this text. So sometimes the text seems to be a bit jumbled together, so I'll try to unravel it for us as we proceed through this. So, Bismillahir Rahmanir Rahim. فقال المصنف رحمه الله تعالى ونفعنا به وبكم آمين. He said, بسم الله الرحمن الرحيم. قال شيخنا ومولانا شيخ الإسلام ومفتي الأنام الشيخ محمد ابن مولانا وسيدنا القاضي عبد الله التمرتاشي الحنفي نفع الله بهما في الدنيا والآخرة آمين. So he says that the Shaykh al-Islam and the Mufti of people, he says that Shaykh Abdullah, who is the son of Sayyidina al-Qadi Abdullah al-Tumurtashi. So of course he is of scholarly a pedigree as well, from the perspective that his father was also a significant and noted faqih. So you can see he's a qadi here. Also his grandfather. And then of course there were Tumurtashis before that as well. So they are quite significant as a family, right? Quite significant as family as well. So he says, حمدا لمولانا على ما منح من التوفيق وشكرا له إذ جعلنا ممن انتظم في سلك من اقتدى بأئمة التحقيق. So he says, praises are due to our master because of the facilitation which he has granted us, and gratitude is due to him for the fact that he has made us amongst those who are associated in this line of duty, so to speak, or this profession of following the scholars of verification. وصلاة وسلام على سيدنا محمد خاتم الأنبياء وخاتم الأسقياء وعلى آله وأصحابه الكرام والأئمة الفخام على الدوام. And then peace and blessings be upon our master Muhammad sallallahu ta'ala alayhi wasallam. He says the seal of the prophets and the seal of those who are generous. He says that upon his folk and his companions, his noble companions, and all of the tremendous scholars perpetually. So he says to proceed, أما بعد فقد كثر الاستفتاء عن مسألة كثيرة الوقوع، وهي ما يقع من بعض العوام على وجه الغلط والتحريف الكلام من إبدالهم لفظ التزويج بالتجويز، فيقولون جوزتك بتقديم الجيم بدل زوجتك بتقديم الزاي. So he says that there have been many questions which have been asked about the issue of the frequently occurring issue, and that's what some of the common folk incorrectly and by way of distorting the proper words speak and utter. He says min ibdadihim lafz by their changing the word tazweej to tajweez. So he says they say jawaztuka by bringing the jim first instead of saying zawajtuka, which is to bring the zai first. Of course, if you haven't already realized or you weren't paying attention, this issue is about marriage wordings, right? So the issue is about whether or not using such a wording would be legitimate such that we can affirm that the marriage has occurred. That's the issue which he is exploring. So he says, فَهْلْ يَنْعَقِدُ النِّكَاحُ بِاللَّفْظِ الْمَزْبُورِ أَمْ لَا? So he says, has the marriage occurred in accordance with this, written word, this word that he's been talking about, or not? وإذا لم ينعقد النكاح باللفظ المزبور هل يثبت به شبهة في المحل حتى لا يجب الحد بالوطء أم لا؟ وإذا لم يجب الحد هل يجب مهر المثل أو المسمى لو كان هناك مسمى أم لا? So he says, so the second question is that if the nikah has not occurred through the usage of this word, is there any type of shubha, any type of doubt which manifests such that the had would not be required if the marriage had been consummated? So under normal circumstances, if there is consummation between a man and a woman, i.e. the intercourse occurs, I'll just say that if intercourse occurs between a man and a woman, there's two cases. either the mahar would be due, or the had punishment, the penal punishment, would be due. So it's either this or that. So that's why he's asking here, because we already have a principle to ward off shubuhat, to ward off the hudud through shubuhat, to ward off the penal punishments by way of doubts and the like. So he's saying, is this sufficient as a doubt such that the penal punishment will not be due? And finally, he says, and if the penal punishment is not due, he says, if there is a musamma, if there is a named marriage payment, would that be due? Or would the mahrul mithl, the dowry of equivalence, would that be due? So which mahr would be due? So these are the questions which he wishes to answer. He says, فَأَقُولُ وَبِاللَّهِ الْعَصْمَةِ. So he says, what I say, and Allah subhanahu wa ta'ala is the one who grants protection from error and the like. He says, الَّذِي نَعْتَمِدُهُ فِي هَذِهِ الْمَسْأَلَةِ عَدَمُ انعقادها باللفظ المزبور وبه كان يفتي شيخنا العلامة المحقق زين ابن نجيم المصري الحنفي وبعض معاصريه من العلماء. So he says, what we hold and deem to be reliable with respect to this issue is that the marriage has not occurred with such wording. And this is what our Shaykh, the verifying muhaqqiq scholar, Zainuddin ibn Nujaym, the Egyptian Hanafi, and some of his and some other of his contemporaries, this is what they had affirmed with respect to this issue, i.e. that it does not count as a nikah. ووجهه ما يستفاد من كلام علمائنا الحنفية في كتبهم المعتمدة منطوقا ومفهوما. So he says, and what's the reason for this? It's based upon the fact of what is understood from the words of our Hanafi scholars in their relied upon books, either explicitly or implicitly, i.e. that he's going to explain what that is now. So he says, فَفِي الْكَنْزِ لِلْفَاضِلِ النَّسَفِي. So he says, for example, in the Kanzu Daqa'iq of Hafidhuddin al-Nasafi, he says, وَإِنَّمَا يَصِحُ بِلَفْظِ النِّكَاحِ وَالتَّزْوِيجِ وَمَا وُضِعَ لِتَمْلِيكِ الْعَيْنِ فِي الْحَالِ. So he says that it's only valid with the wording, i.e. if the person uses the word nikah or tazweej, or they use the word excuse me. So either nikah or tazweej, or something which has been coined in order to indicate ownership of an item immediately, i.e. immediate ownership of an item. So he'll explain what that is in just a second. He says, قال شارحه العلامة الزيلعي. So Zailai, who is the author of the Tabyin al-Haqa'iq, one of the tremendous commentaries on the Kanzu Daqa'iq, and from Zailak himself, he's from the Horn, I guess, i.e. the Horn of Africa. He says, أي لا يصح النكاح إلا بهذه الألفاظ. He says that nikah is not valid except with these words. He says, لا شك في إفادة إنما الحصر عند المحققين من الفضلاء. He says, no doubt that the word إنما is there's no doubt in the fact that it's an expression whereby he is restricting something. He says عند المحققين من الفضلاء. So according to the ulama, he says ومفهومه حجة عندنا في الروايات. So he says, and the mafhum, what's understood thereby in the riwayat of the madhab with respect to the texts of the nusus which we have from the ulama, he says this is considered to be a hujjah, كما صرح به المحققون من علماء الأصول في كتبهم المعتمدة. He says, just as these verifying scholars of usul, i.e. usul fiqh, in their relied upon primers have expressed, وفي عبارة بعضهم, and he says, and some of them have said, إذ النكاح لا ينعقد إلا بلفظ الإنكاح والتزويج وما وضع لتمليك العين في الحال، ولا شك في إفادة كلمة إلا القصر كما هو مسطور في محله. Is it قصر here or حصر, as he said before? We might have to check the manuscript for that. But he says, he basically expresses the same thing. He says, because the nikah is not, i.e. the contract of nikah is not effected except with the word of ingah or tazweej, i.e. using these types of words. He says, and also anything which has been coined in order to indicate an immediate transfer of ownership of the ayn of something, i.e. of the entire entity of something. And he says, and again, there's no doubt that the word illa indicates that it's only acceptable with these types of words as is expressed in its proper place. Of course, they would mean, if they're mentioning in usul al-fiqh, in the books of fiqh, which is obviously what the first thing he said was to us anyway. He says, وفي كلام بعض أصحابنا التصريح بعدم انعقاده بغير التزويج والإنكاح وما وضع لتمليك العين في الحال فقد. So he says, and some of the ulama and some of our fuqaha have said what? They've explicitly mentioned that it's not acceptable with other than these types of words, i.e. these three types of words that we've been looking at. So he says, فقد ثبت بمفهوم كلام أصحابنا وبمنطوقه أن النكاح لا ينعقد إلا بما ذكر من الألفاظ. So he says, so this is why he mentioned previously that it's established both mantuqan and mafhuman. Yeah, this is where he said في كتبهم المعتبرة منطوقا ومفهوما. Mantuqan, i.e. they explicitly mentioned it, mafhuman, that it's understood from their words. So he says that because of the innama and the discussions thereby, they have affirmed to us that it's restricted to certain types of words. And then he says, وفي كلام بعض أصحابنا التصريح. They mention explicitly that it's only acceptable with these words. So he says, so it's established now that you can only use these types of words. He says, وإنما بقي الكلام if I can find, oh yes, yeah. He says, وإنما بقي الكلام في لفظ التزويج, oh sorry, التجويز. See, even I'm getting it mixed up. I'm pronouncing it the right way though. He says, من حيث له, أو من حيث sorry, أنه هل بينه وبين ملك المتعة اتصال حتى يصح استعارته له كما استعير لفظ الهبة والبيع أم لا. Okay, so he expresses now, so if we consider the issue of can you use the wording of bay'a or hiba in the marriage in order to effect a marriage, the answer is yes. Why? Because these are words which are used to indicate the immediate transfer of ownership of the entire object of something, right? The entire thing. So from the perspective that such words are being used, and something like this would be a sabab, i.e. using these types of words would be a sabab or a cause for possessing the exclusive right to engage in relations with this other individual, i.e. this person of the opposite gender now. How so? Through the fact that you come to that using wording which indicates an ownership of the whole thing, but of course there's that doesn't apply. So it's almost like you are you're using language which doesn't apply literally, but it's more figurative in its nature. So this is what he's saying over here, that the only issue which remains now is whether you can use tajweez from the perspective that there is some type of relation between the idea of between it, i.e., what it means, and what the idea of attaining unto this right to benefit, intimately from the other party, just as there is with a word like bay' or a word like hiba, as I just explained, from the perspective that you come to own, so to speak. It's almost like he's expressing, because this word is used to express ownership of the whole thing, but the only thing we're looking for in the marriage is ownership of the specific thing, right, of something specific. So given that there is some relation between these two things, they deem it to be acceptable to use these other wordings. So he's saying, can we apply the same principle to something like tajweez? So would it have to be in the Arabic language, or any other language is acceptable if they use similar words? That's coming. So Yasin, so we'll see. He's going to address that shortly. So he says, وَالظَّاهِرُ أَنَّهُ لَا اتصال بينهما. So he says what seems to be the case, and what seems to be apparent, is that there is no relation between these two things. He says لأن التجويز إما بمعنى جوز الفقيه كذا. So he says because the meaning of tajweez is that either it's used with the meaning of that a faqih has permitted such and such, إذا قال بحله وجوازه, if he deems it to be lawful and permissible. وإما بمعنى جوزته أي جعلته جائزا بمعنى المرور وليس واحد. So he says, otherwise جوزته, that I passed, or I made it into a something that you can go past, like a walkway or something. So he's saying that none of these meanings have anything to do with ownership. Right? That's the point. So he says, وليس واحد من هذين المعنيين يصح علاقة للاستعارة. So none of these meanings now are acceptable to use as some point of relation for the isti'ara, i.e., for this figurative usage now. He says, والعلاقة وهي جعل اتصال المعنى المستعمل فيه بالمعنى الموضوع له شرط لصحة المجاز كما صرح به المحققون. So he says now that this علاقة, this point of connection between these two things, he says that's to make a اتصال المعنى المستعمل فيه some point of connection between the ma'na which you are using with the ma'na for which the thing has been placed, as we talked about earlier. So the fact that they were both talking about milk or ownership, one can be used for the other. This is just how majaz works. So this is what he's going to explain in a second. But it's the same reason why it's acceptable to say, or to use, for example, a lion for a human being from the perspective of bravery, right, or courage, or the like, because the lion is a courageous or brave animal, and then somebody is behaving in a brave kind of manner, and then you can use one for the other. This is how majaz works. There has to be some type of relation or between these two things. If there is no such relation, you can't affirm invent a majaz. That's not how it works. Of course, you can invent words and the like. That's a different discussion. But you can't affirm that this is majaz. That's his point. It's not being used literally. It's a figurative usage of this particular word. So he says this as the verifying scholars, and these scholars have clarified. He says, ومن ثم صرح أصحابنا بأن النكاح لا ينعقد بالإجارة والإحلال والوصية لعدم صحة الاستعارة كما بين في المطولات. So he says, so this is why our ulama have explicitly explained, that the nikah is not deemed to be acceptable if wording such as ijara or ihlal or wasiya is used, i.e. ijara, renting or making something halal, or leaving a bequest. So this is not deemed to be acceptable. He says, because the isti'ara here, the figurative usage, is not possible to kind of connect between these two types of meanings, because it doesn't authorize you in, it doesn't fit the ma'na of nikah, because nikah is talking about a complete ownership of something. That's not what you get through something like ijara, because what you own is the manfa'a, is the benefit. You don't own the ayn of the thing. So these are separate realities. These types of words are not considered to be legitimate. So he says in the larger text, you can see that this something like this is not acceptable. So the figurative meaning has to mean ownership. They have, so in any word that we're going to be considering, there has to be a point of connection between the two realities. If I'm using a different word to express this reality, there has to be a point that is shared between them. That's what he's trying to express. So that's why in our case, or in the case of nikah, what they have expressed in terms of words which are legitimate to use are words like the bay'a or the hiba. Why? Because the meaning of these things is milk, is the tamlik, like the ownership of the whole thing. That's what's understood. So, and here, what does nikah do? It makes it makes benefiting, i.e. intimately, from the opposite gender lawful. So it gives you an ownership of this right, an exclusive right. So that's a specific right, and bay'a and hiba and the like give you a general ownership that includes that and everything else, so to speak. So there's a point of there's a relation here. So he's saying that with some of these other words, you don't have that. That's why they explicitly mention that it's not legitimate with this or this or this. Right? So I deem it okay for you to eat my plate of biryani. So this is me making it lawful for you to do that, but you don't own it. Right? I might say it's okay for you to do this, but you don't own it. So I can't use that word for nikah. That's the point. It's like, now it sounds like I'm comparing a plate of biryani with nikah, but anyway. So he says, وأنت خبير بأن الاستعارة لا تصح بكل وصف للقطع بامتناع استعارة السماء للأرض مع اشتراكهما في الوجود وغير ذلك، بل لا بد من وصف مشهور له زيادة اختصاص بالمستعار منه، كما حققه مولانا سعد الدين في التلويح وغيره في غيره، وهذا غير متحقق بين ملك المتعة ولفظ التجوز كما لا يخفى. Of course, it might again be tajweez over here. That might be a typo, but we'd have to check the manuscript for that. But he says here that you are well aware now that the isti'ara, he says, is not acceptable, i.e. that this figurative usage of a word now, it's not acceptable with any type of wasf. So when we talk about something, then we are looking at the different type of awsaf, right? So it has different types of characteristics. So you look at a car, it's made of metal, that's a wasf. It is a blue car, for example. It is a Ford. It is like this. It is like that. It's an automatic, it's not manual, and so on and so forth. These are awsaf. So he says, when we're using one thing in place of another, then we are looking for not just any point of comparison between the two things. he says this is why it's not acceptable to use the sky to refer to the ground, right? In the sense that or the ground to refer to the sky from the perspective that he says that they share in a wasf. What is the wasf? That they both exist. He says that existence alone is not sufficient to use in this case. Rather, it has to be an obvious wasf. You can't just say a lion exists and a stone exists. Therefore, I can say the stone is so brave. Even me saying that probably doesn't make much sense, but even if we think about that as an example, like it's not acceptable just because, well, the lion exists and the stone exists, so therefore I can use one word to refer to the other word. There has to be a point of comparison. There has to be something by which, some obvious thing by which it's conceivable that we can use one word for the other. So he says it has to have that's what he expresses here, and that's when he says that Sa'd ad-Din al-Taftazani says in his Dalwih, which is the Hashia on Sadr al-Shari'ah's Tawdih, and it itself received many commentaries. But he says also other scholars in other works also said the same thing, and he says that this is now not apparent between the exclusive right to intimacy with the opposite gender now. He says, and the word tajweez, as we've been looking at in his previous paragraph. He says, فَإِن قُلْتَ, so if you were to say, المسطور في الكتب المعتمدة انعقاد النكاح باللغة الأعجمية. This is now Sidi Yasin's question. So he says that if you say what's also mentioned in the relied upon books of the madhab is that the nikah occurs if somebody uses foreign languages, right? So a foreign language. He says, وَهِيَ لَيْسَتْ مَوْضُوعَةً لِذَلِكَ فِي اللُّغَةِ الْعَرَبِيَّةِ قَطْعًا. And he says, and obviously those words they aren't used for the purposes of marriage in Arabic. I mean, that's obvious. Remember, the fuqaha said what? They said that you can only use specific words. So is it acceptable then for me to do the marriage, conduct the marriage in another language? So he says, فينبغي القول بانعقاده بلفظ التجويز بدو بين قوم يقع بينهم ذلك ويكون كالأعجمية لاتفاقهم عليها وتخاطبهم بها. So he says, so based on that, given the fact that we can look at other languages and that's acceptable, it's acceptable to use other languages other than what the fuqaha have now mentioned, that you're telling us that this is legitimate. So he's saying that if they talk like this, then why is it that we can't simply consider this to be a language which is specific to them, right? It's a language which is specific to these people, i.e., this is how they talk. So it's almost like it's a new language. That's why we said they're not speaking in Fusha. They're speaking in their own dialect, and they've made this word that word, as it were. That's what he's trying to say. Yeah, Sheikh is explaining that there is no presumed shak if words that are not commonly used with figurative meaning of tamlik. Sorry, maybe I'm not quite understanding the question. Maybe you can rephrase. He cannot say any word and say I intended marriage. Correct. Yeah, correct. So he can't just say anything. But of course he's going to mention a couple of details now. But what the point that this interlocutor is saying now is that look, the ulama have deemed it to be acceptable to use foreign languages, and they are not holding themselves to classical Fusha, eloquent Arabic, as it were. They've invented their own personal, private dialect, and that's how they talk. So they use this word to refer to zawaj. So we're not saying now it's on the basis of majaz, because that was a previous discussion. right? So now he's tackling it from a different angle now. That it's almost like, okay, we accept the fact that you can't do it in a figurative kind of way. That this is not acceptable, just like other words can be used figuratively to refer to nikah. So now he's tackling it from a different angle. And yes, a discussion of urf now. Exactly, it's pretty much it. That we're tackling it from a different perspective on language. That language returns to a certain people. They talk in this way now. So can we not deem it to be acceptable, given that this is how they express themselves? That's the question. So he says, قلت اعتباره باللغة الأعجمية صحته غير لائحة لأن اللغة الأعجمية تصدر عمن تكلم بها عن قصد عن قصد صحيح واستعمال رجيح. So he says, now that it's being acceptable in a foreign language, its validity is not unclear. He says because a foreign language, the one who expresses marriage through it, is expressing, is using words whereby he's deliberately saying this word, and it has a clear and obvious meaning. He says, بخلاف لفظ التجويز. He says this is different to using the word تجويز. فإنه يصدر لا عن قصد صحيح. Because when somebody says تجويز, they're not using, it's not with a correct, it's not purposefully said. It's not purposefully said. Why? Because بل عن تحريف وتصحيف فلا يكون حقيقة ولا مجازا. He says, but rather because they're not deliberately saying tajweez, as it were. They're trying to say tazweej, but then they say tajweez, right? So they mix up the zai and the jim. So he's saying this is not a proper qasd like somebody who says it in a foreign language where they mean the word that they're saying in that foreign language because that means nikah. So there is a word in Ajamiyya, tajweez, to refer to marry, not just to pronounce it. No, tajweez is not the point. The point is that can you say, for example, that can a man say to a lady, "I marry you"? So is this acceptable to say? So this is what he's trying to say. If you use the words marriage, for example, in English, right, or in any other language, is this legitimate? So he's saying that this is fine because it's clear what the person is saying. They are deliberately using this particular word. His focus now is on the idea of the qasd. So what he's trying to say is that the person who is speaking in this common dialect, they are not trying to say tajweez. That's what came out. They're trying to say tazweej. So he's saying they are just speaking wrong. So he's saying it's not acceptable for us to say this is haqiqah or majaz. This is just a mistake. So a word in another language that clearly means to marry would be acceptable. But the issue is here, going back to tajweez, he's saying that's not acceptable because this is not a word which means that. So he says, فَقَدْ قَالَ خَاتِمَةُ الْمُحَقِّقِينَ السعد التفتازاني. Yeah, so Imam Taftazani again says here, في بحث الحقيقة والمجاز من التلويح اللفظ المستعمل استعمالا صحيحا جاريا على القانون إما حقيقة أو مجاز. So he says a word which is used properly, it's either going to be haqiqa or it is going to be majaz, i.e. it's going to be a word which is used literally or it is used figuratively. He says لأنه إن استعمل فيما وضع له فحقيقة, because if you use it for that for which it was placed, i.e. coined for this particular purpose, lion in the zoo, then this is a literal usage of the word. وإن استعمل في غيره فإن كان لعلاقة بينه وبين الموضوع له فمجاز. He says if it's used in another way, i.e. not in the manner for which it was placed, if there's some type of relation between these two things, then it is deemed figurative usage. So I say the lion in in the I don't know, somebody's playing a game or something, right? And he was like a lion. Right? So he was like a lion. So i.e. that he was really into it, or he was very brave in the decisions that he was making, and so on and so forth. So he says, وَإِلَّا فَمُرْتَجَلٌ. Otherwise, it is a newly invented word, so to speak. وهو أيضا من قسم الحقيقة. And he says, and this is also from the literal usage. لأن الاستعمال الصحيح في الغير بلا علاقة وضع جديد. Because if you like sound usage in this other way without any point of correlation, right, relation between these two things, is new coinage. فيكون اللفظ مستعملا فيما وضع له فيكون حقيقة. So you're using the word, because it's new coinage, it's almost like you invented a new word. So you're using it literally now. It's a new word which is being used. ثم قال وقيدنا الاستعمال بالصحيح احترازا عن الغلط مثل استعمال لفظ الأرض في السماء من غير قصد إلى وضع جديد. So then he confirms, because although that looked like, okay, then it seems like it must be fine. He's saying, no, actually, he says the reason why we keep saying استعمال صحيح, أي استعمال بالصحيح, that using it properly is in order to exclude making a mistake. So he says, such as using the earth to refer to the sky. He says من غير قصد إلى وضع جديد, without trying to make a new word. That this is almost like a slip of the tongue. That's what he's saying. So he's saying if it's a slip of the tongue, it doesn't apply. Right? He's saying it doesn't apply. We're not talking about slips of the tongue. We're talking about deliberate usage. Slips of the tongue don't have any hukam. Right? I.e. that the asl is that this is not representative of new coinage or anything. It's just a mistake. You just made a mistake. So he says, نعم لو اتفق قوم على النطق بهذه اللفظة بحيث أنهم يطلبون بها الدلالة على الاستمتاع وتصدر عن قصد واختيار منهم فللقول بانعقاد النكاح بها وجه ظاهر لأنه والحالة هذه يكون وضعا جديدا منهم. He says, yes, if a people come together, right, and they agree to utter a certain word in a certain way, such that they are seeking thereby to use this word to signify the istimta', which is the right to engage in intimacy with the opposite gender. He says, and it occurs عن قصد واختيار منه, that deliberately and out of a willful choice. He says, then saying that their nikah is deemed to be valid it's clearly plausible, right? وجه ظاهر, there's an obvious case to deem this to be acceptable, because they are deliberately trying to do this. He says, yeah, because this is new coinage, right? لأنه هذه يكون وضعا جديدا منهم. وأما صدورها لا عن قصد إلى وضع جديد كما يقع من بعض الجهلة الأغمار فلا اعتبار له. He says, again, returning back to the idea of tajweez, he says, as for its occurring without somebody deliberately trying to coin a new word for this particular thing called marriage, he says, as occurs from ignorant, naive kind of people, he says this is of no consideration. فقد قال خاتمة المحققين مولانا السعد التفتازاني في التلويح إن التحقيق أن استعمال اللفظ في الموضوع له أو غيره طلب دلالته وإرادته منه فمجرد الذكر لا يكون استعمالا صحيحا فلا يكون وضعا جديدا الله أعلم. So Sa'd al-Din al-Taftazani in Talwih, what does he say? He says the tahqiq and the soundest explanation of this issue is that the usage of the word for that for which it was coined for, or for something else, he says طلب دلالته وإرادته منه, is seeking the signification, right, or the intention of that particular thing. He says for مجرد الذكر, so as for simply mentioning it as a one-off thing, as a slip, as we were talking about it before, he says this is not isti'mal sahih. This is not a legitimate usage of the word. He says, therefore, it is not a new coinage. New coinage will only manifest when it is proper, it's deliberately done, it's done with qasd, it's done with purpose. They agreed to kind of do it in this particular way, they meant it like this, and so on and so forth. And here, again, he's using this line of this is the second line of argument, of course. This second line of argument, he's telling us that they are simply making a mistake. They're just not pronouncing it correctly. So we cannot affirm now that the marriage has occurred, given that they did not intend to do it like this. That's the whole issue here. Um, I will where's the yeah, so of course this is where there is a bit of an issue, and I will mention in just a second, but I will say one thing that Ibn Abidin mentioned here, for example, he said, وَإِذَا سُئِلَ فِي عَمِيٍّ I can't remember now if he might be quoting somebody. في عَمِيٍّ قدم الجيم على الزاي بلا قصد استعارة لعدم علمه بها بل قصد حل الاستمتاع باللفظ الوارد شرعا فوقع له ذكر ينبغي فيه موافقة الشافعية because the Shafi'is have this particular position. So he says, if somebody is asked about an individual who brings the jeen before the zai, he says tajweez, as we've been talking about, without intending thereby the figurative usage because he doesn't know about that, but he intended through this particular wording to make the spouse lawful for himself, as has been expressed by the Sharia, i.e., as the Sharia is seeking from him, i.e., to use certain words in order to make this a lawful contract to marriage and the like. He says, and then he says this type of thing, then it seems appropriate to agree with the Shafi'is on this particular point, and say that it's still a marriage, i.e., that if you have a slip in trying to express yourself, it's okay. That's what he mentions over there. Anyway, we'll come back to that in just a moment because we're almost at the end of this now. Yeah, so he is distinguishing between coinage of a new term from a slip of the tongue or mispronunciation. Correct. That's correct. So he just finishes this the issue of that's the end of what he wanted to say over there. So he says إذا تقرر هذا يبقى الكلام في الوطء الحاصل في النكاح الذي وقع بهذه الصيغة إذا قلنا بعدم انعقاده ما حكمه. So he says, if this is established now, the only thing which remains is to consider the intercourse which occurred in this, as a result of such words having been uttered. So he says, if we deem it to be illegitimate, that it was not legitimate, the Amar, then he says, then what's the implication of this? So what's the ruling? He says, فأقول قال المحقق الكمال في شرح الهداية من كتاب النكاح. So he mentions now that the verifying scholar al-Kamal ibn Uthman in his Fath al-Qadir, in his sharh on the Hidayah, in the Kitab al-Nikah, he says كل لفظ لا ينعقد به النكاح ينعقد به الشبهة. Remember the second question he asked at the beginning of this risala was that, is there any type of shubha which manifests, any type of legal doubt which manifests, such that the penal punishment or the had punishment would thereby not be due? So is there a shubha in using these words? So he says, every wording which is used by which we affirm that the nikah has not occurred, then he says a shubha would manifest thereof. فيسقط به الحد. So he says that the had would not be applicable thereby. ويجب لها الأقل من المسمى ومن مهر المثل إن دخل بها. So when is the mahar due? The mahar is due as a result of the consummation, because if there was no contract, then no mahar is due. But if there is consummation of this marriage, then remember we talked about the principle that لا يخلو عن عقد أو عقد, that it's either there will be a had punishment or there will be a mahar which is due. So that's why he says the lesser of either the musamma, which is the named marriage payment, or the mahrul mithl, the dowry of equivalence, would be due. So those are the answers to those two questions. So he just brought them both together. And then he says, Wallahu a'lam bis-sawab wa ilayhi al-marja' wal ma'ab. Of course, one other thing, sorry, before that I wanted to say, I just remembered now. لا ينعقد به النكاح. So of course he says that every utterance now by which the nikah would not be legitimately done. Of course, this would refer to words which are clearly indicative of some type of ownership and the like. So it's not simply any wording that he says, you are my hot potato. And he says, I accept to be your hot potato. And he says, I meant marriage thereby. They would receive the had for that. This is not acceptable. Rather, it needs to be something which clearly is indicative of ownership. So that's just as an aside. He says, Wallahu a'lam bis-sawab wa ilayhi al-marji'u wal ma'ab wa sallallahu ala sayyidina Muhammad wa ala alihi wa sahbihi ajma'in wa ala tabi'in wa tabi'i tabi'in lahum bi ihsanin ila yawm ad-din walhamdulillahi rabbil alamin. So alhamdulillah, that's the end of this risala. The one thing that I wanted to share with you was actually from Khairuddin al-Ramli. So Khairuddin al-Ramli in his Fatawa al-Khairiyah, so this is now published, the Fatawa of Khairuddin al-Ramli. It's published by Anwar al-Azhar in 3 volumes. And on page 97, he actually has this issue. So these are his Fatawa. So he's asked about it. So he says, هذه المسألة اختلف فيها المتأخرون. So I know we haven't necessarily done this much. I mean, 1 or 2 times we've kind of looked elsewhere as well. But anyway, I just thought it was interesting. So I'll read just a little bit of it. He says, هذه المسألة اختلف فيها المتأخرون. So he says this issue, the later scholars have differed about it. منهم من قال بعدم الانعقاد. So some of the scholars have said that it does not count. Right. So of course, Khairuddin al-Ramli, he is coming. I can't remember if it's a century or so after Tumurtashi, but he's coming after. So of course, that would be in reference now to somebody like Imam Tumurtashi. He says, وَمِنْهُمْ مَنْ قَالَ بِالْإِنْعِقَادِ. And some of the ulama actually said that no, this would actually count as a valid marriage. He says, وَقَدْ أَفْتَى شَيْخُ الْإِسْلَامِ أَبُو السعود الْإِعْمَادي رحمه الله تعالى بانعقاده بين قوم اتفقت كلمتهم على هذه اللفظة. So he says Shaykh al-Islam Abu Saud al-Imadi, so he deemed it to be legitimate if this is wording which they have accepted amongst themselves and they use it to mean marriage, as he was talking about before. Of course, Tumurtashi did not like for that to be the case, but he's saying that some of the ulama deemed this to be legitimate. And then he mentions a significant quote, a lengthy quote from the Fatawa al-Zahiriyah, and he says, let's see. Yeah, so I don't want to read it's kind of a long quote, so I don't read the whole thing. But anyway, he says Khairuddin Ramli, he kind of singles out something. He says فتأمل في قوله وإذا عرف الجواب في الطلاق والعتاق ينبغي أن يكون النكاح كذلك وقد عرفنا الجواب في الطلاق أنه واقع مع التصحيف. He says, if you mess up the letters of the talaq, you don't say talaq properly, but you mess something up, he says still counts as a talaq. So he says, so the same thing applies to the nikah. He says فقد ظهر لك بهذا صحة قياس النكاح على الطلاق فتأمل. And then he mentions And then he mentions, as for the final discussion of Tumurtashi, this idea then about these naive, ignoramuses, as it were, these ignorant people using this wording, and they don't actually know what's happening. He says, إذا العامي, he says غير ملاحظ لهم أصلا إذا العامي بمعزل عن درك ذلك وحيث كان تصحيفا وغلطا فجميع ما جاء به لا يصلح لإثبات المدعى. So he says that everything that Tumurtashi's second argument now, he's saying that this is not acceptable. It's the second argument is not acceptable because this does not apply with respect to the Ammi. So he clarifies this further and he says, نعم لو صدر من عارف تأتى فيه ما تأتى في الألفاظ مصرح بعدم الانعقاد بها. So in this case, if it occurs at the hands of somebody who knows, right, who knows what this means and the like and the implications of it, he says, وهو والله أعلم محل فتوى شيخ زين ibn نجيم ومعاصره. So he says this is the mahal of the fatwa. He says فيقع الدليل في محله حينئذ. And then he mentions a couple of other things that he ends his fatwa at that point. But the interesting other fa'ida in this whole thing, so of course it just shows you that there's a bit of discussion about it. Ibn Abidin also seems to be inclining towards it being okay, right? So in his hash. But what's also quite interesting over here is how he talks about the mahal of the fatwa. So you can see how Tumurtashi is saying that's his sheikh, right? It's his sheikh, and he's saying that this is what the fatwa is. But Khairuddin al-Ramli is saying, no, this is not the mahal of the fatwa. I.e., that this is not how the fatwa is supposed to be applied. So they're differing about the application of this fatwa now, like the mafhum of it, the mahal of it. That is this locus a valid locus to apply this fatwa? We don't disagree on the dictates of the fatwa, but we are disagreeing now about the locus of the fatwa. That is this locus an acceptable locus for this fatwa? So this is why Tumurtashi says yes. Right, this is an acceptable locus. And Khairuddin al-Ramli, what does he say? He says, no, this is not the locus, this is not an acceptable mahal for the application of this fatwa. So you cannot simply, although it's the mafhum of it, but the idea is that you always have to consider whether the mahal is appropriate for such a fatwa. So that's a really important nuance and insight to just as a general point to keep in mind when it comes to fatwas and the like, because sometimes people don't necessarily pay attention to these types of things. We can agree that this is the issue that, for example, which the ulama have mentioned on a certain point, but the question is whether the mahal that you are looking at, whether it applies to this mahal or not. So we both agree on what that means, but does it apply to this mahal? That's a separate question. So that's why Tumurtashi, once again, is saying that yes, it applies. It applies to this jahil, this ammi who is a complete jahil, and it applies to the alim. Right? That's somebody who knows, not somebody who's like an alim, like a sheikh, but somebody who knows and somebody who's a jahil. But Khairuddin al-Ramli is saying that no, if he's a jahil, he's not responsible. So he's not the mahal of this type of fatwa, and so that's quite an interesting nuance, and it's actually important fa'idah to keep in mind when considering just fatwa and the like. The fact that somebody issued a fatwa or said something or transmitted something does not necessarily mean that it applies in every single locus thereafter. Rather, there's always some considerations which will manifest with it as well. So alhamdulillah, I did mention that today's reading might be a bit more technical than some of the previous readings, but Thankfully, it was a bit shorter, so everybody, inshallah, hopefully was able to keep up with it. And inshallah, we will end with that, and inshallah, we'll meet again for our next reading soon, بإذن الله تعالى. So جزاكم الله تعالى خيرا. صلى الله وسلم على سيدنا محمد وعلى آله وصحبه وسلم. الحمد لله رب العالمين. السلام عليكم ورحمة الله وبركاته.